wonder if the Galaxy tab was just a different hearing. Maybe that's why she left.
Yeah.
All right, we're gonna go on the record in the matter of Guajardo versus Guajardo, 2258564 DM. This is the date and time scheduled for a couple of hearings. Defendant's motion regarding spousal support and a status conference. I have both attorneys appearing via Zoom and both the parties appearing via Zoom. Ms. Wickander and Ms. Smulders and their parties, everyone's appearing via Zoom. I guess first of all, we can start with, well, I guess Ms. Smulders or Ms. Wickander, can either one of you tell me where you guys are at with this case? I know last time we were here, we were talking about spousal support, proof of income at the last hearing, and I'm not sure, Ms. Wickander, you were involved at that point. I know they went to front of the court, and front of the court is waiting on them to return their consent order. So if one of the attorneys want to give me an update as to where you guys are at with this case.
So I'm getting weird feedback. Is that?
I am getting that feedback as well. I'm going to actually mute Miss Guajardo. I think actually it's coming for some reason from her screen.
Okay. Can you hear me okay now? For some reason, it says Newego probate courtroom is muted now. All right, can you hear me now? Okay.
Yep, sorry, I don't know why, but sometimes it has a mind of its own.
Around as I was trying to.
Oh, the boxes were moving like the Brady Bunch.
Yeah.
All right, so I am unmuted. I muted Miss Guajardo just for a minute. I think the feedback was coming from her screen. So go ahead, Miss Smulders.
Okay, I don't believe there is honestly much of an update. I know my assistant had indicated that Ms. Guajardo did obtain an attorney, so I didn't know that prior to, I don't know, 10 minutes ago at this point, Your Honor. That being said, I hadn't had a chance to reach out, of course. I know we're doing our continuation hearing for spousal support. I did not receive any sort of proof of income directly from Ms. Guajardo. I don't know if Ms. Wickander sent that over or not, so I'd have to kind of defer to her on that. And so, I mean, unfortunately, Your Honor, that's not much of an update. My client situation hasn't changed other than the fact that, you know, he desperately needs some sort of additional income so he can find a place to live.
All right. So Ms. Wickander, just an update to you, and maybe you know this, but the last time we were here in December, there was a motion for spousal support. They were discussing, your client was going back to work. There was some disagreement as to how many hours she was getting. She said she was working on getting more hours. I adjourned it till mid-January for her to bring proof of her income at the next hearing. We set a status. I said I was going to set status for February, but we set status because they had agreed on a number of things. I think they have a temporary custody and parenting time agreement that they agreed to with Ms. Herman from front of the court. Again, I don't think they have sent that consent order back. The way it works here is they meet with front of the court. If they come up with an agreement via Zoom, she'll draft it and she sends it to them. They're supposed to both sign it and return it. And I'm hearing from friends that they have not done that yet. So that's just an update from our end, Ms. Wickander. So I guess if you want to respond or give us an update as to where you think you're at. Oh, you're muted.
Thank you. Sorry. I apologize to opposing counsel. We sent my appearance and a response to the motion a week ago. So, and I believe my assistant sent it by email and mail. So, I've just, unfortunately, I've been swamped, so I haven't been able to reach out, and this status conference was on the schedule. I do have my client's end of year pay stub, and I have her most recent pay stub. And just so the court's aware, in 2022, her end of year pay stub showed she made $4,200. So we're not talking about any sort of substantial income here. And I don't believe she's receiving child support. I know she receives disability income through Mr. Guajardo, but she's not receiving any child support. And she has, I believe, primary custody. In terms of the FOC order, I was unaware that was not entered. So I will make sure that she understands what she's supposed to do to get that back to you. Just one second, Kyle. She is in the process of obtaining full-time employment through her same employer. It's a federally funded position. And so it's just not moving as quickly as she would like. When she does start working full-time, she's going to be making the same hourly rate of $19.86 per month. Where we have a problem here, Your Honor, first of all, I don't believe spousal support is appropriate. I haven't seen anything in terms of a real budget or need. And clearly Ms. Guajardo doesn't have the ability to pay any spousal support right now. But where we're going to have a serious problem is that in order for her to pay him any equity on this property, she's going to have to get financing. And in order for her to get financing, she needs to start that full-time employment. There's no debt on the property, but she doesn't have full-time employment. So she won't be eligible for financing. And if she's also on top of that paying spousal support, that's going to reduce her debt to income. And then we're never going to be able to get him any money for his equity in the property. And she doesn't want to sell the property. This is a family-owned farm and property that she purchased for very, very inexpensively. So quite frankly, Mr. Guajardo is going to be getting probably a bit of a windfall given how much they actually purchased it for, and there's no debt on it. But right now she doesn't have the funds to pay him any spousal support. And if he's going to be awarded spousal support, she's not going to be able to get any sort of financing at any point in the future to be able to pay him his equity. So then she's going to be out a place to live as well. So it's just there's no money to go around. I get it. He needs support, but there's no money to pay him the support.
Yeah, that was what we were kind of afraid of the last time we were here and we talked about a little bit. Yeah, it is. And then the added problem of paying him is a giant catch-22. I mean, and the reality is, and your attorneys are going to tell you this, I mean, if you can't get refinancing and there's equity in the home that's marital, unfortunately, I mean, most circumstances, I'm going to order that house sold. So I understand that that is not optimal for anyone, especially in this housing market right now, because there's nothing to rent and you don't want to buy right now. So, you know, I'm just warning people, if there's not enough money to go around, we have to start selling things. So hopefully we can get that issue addressed. Ms. Smulders, any response to what Ms. Wickander stated?
Yeah, I understand somewhat of a circular argument here. However, I mean, we need deadlines. We need timeframes at this point. My client makes about $1,100 a month on Social Security. He, like I stated previously, he has been disabled for a number of years. This is nothing that is new to Ms. Guajardo. If counsel then is correct, she's making almost closely to what we stated then in our motion, which would be $20 an hour. When she does work full-time, we equate that to be about $3,400, plus she does receive that Social Security on behalf of the children, which is another $600. So we're looking at $4,000 a month. Again, I understand she's not making it currently, and if there is no money, I'm not sure where it's going to come from, but we need timelines now, Your Honor. I don't even know if she would be able to then, based on $20 an hour, to even be eligible for a refinance, not even taking into a spousal support order or not. So, I'm not sure if any legwork has been, started on that end to even see where she is at, if there is a pre-approval or anything. But the fact of the matter is my client is living in his son's basement. His son, I believe actually the court is aware of who his son is, because there's been cases through that I have represented through this courthouse as well. But, they have, I believe, 4 or 5 now, I forget now, boys also that live in that home, so we just need some answers, Your Honor, at this point.
All right, well, I'm looking at the filing. They filed in September. We did do a scheduling order, Ms. Wickander. Their waiting period ends in March. My thought is, you know, we can fumble around a lot for a temporary order. It doesn't seem to me that that's gonna change anytime soon. I think I just need to get them on the docket for a trial date for the divorce as quick as I can, and then at that point in time, hopefully, she'll have enough time in at her job that she can get some money to refinance. And then I'll just reserve the spousal support argument, Miss Smolders, for the trial. And if at that point in time, it appears clear that she had substantial money, I mean, the other thing is discovery was supposed to end today. Obviously with Miss Wickander coming in, I think we need to extend that discovery time, so you guys can try to work through, some of these issues. Any thoughts? It looks like I could get them in April.
That would work for me, Your Honor.
Yep, April should be fine, just obviously depending on
right.
the date and time.
Yeah, so I'm looking at April 13th. That's a Thursday.
April. Yep, I'm wide open on that day. Would it be morning or afternoon?
It would be morning and it would be all day.
Okay,
I'm good on that date as well, Your Honor.
Great. All right, we'll put you on the 13th at 9 a.m. That will be in person. Miss Wickander, my philosophy is, I mean, if you guys are arguing over one thing, I don't mind doing it by Zoom if you guys agree. But if we're gonna have multiple witnesses, multiple exhibits, I mean, typically I want you here in person.
yep,
We'll do a settlement conference the week, actually a couple weeks before March 27th, and this would be by Zoom. So does that date work for you guys?
Yes, Your
Monday
Honor.
the 20th, yep. What time on that? Would it
Or-
be 10?
Do you want morning or afternoon?
I prefer morning on that day.
And I'm fine all day.
All right, we'll do 9 a.m. That'll be a settlement conference, and that you can do by Zoom.
Okay,
The
Okay.
parties, anyone who has connectivity issues, we have pretty bad service up here. So at any point in time, if the parties want to appear in person, even if the attorney comes by Zoom, I'm fine with that as well.
Okay.
And then we'll work on getting that consent order back to Ms. Herman. That's a temporary order, and that will assist us in hopefully getting some of those issues resolved. And then I'll reserve spousal support for trial. Anything else for today?
Any orders that need to be, I'm sorry, any orders that need to be drafted then today or?
Oh. And I'll extend discovery.
Mhm.
and when would that close, Your Honor? Like 30 days before trial?
Yeah, what did I say trial was? 4/13, yeah, so 3/13, does that work?
Yep.
Mhm.
All right. Miss Aubrey, do I need an order for any of that?
Probably yes.
Yeah, if one of you could do the order, that would be great.
I can, and just reserving the issue of spousal support, trial, settlement conference date, and discovery extended. Is that
Perfect.
till, okay, perfect.
Yeah. All right, anything else for the record today?
Nothing,
No,
thank
Your
you.
Honor.
Oh, Kyle, did you have something? I'm sorry.
I just wanted to say regarding friend of the court, those papers were signed on my end and were handed to Mr. Wahardo. And he was
Perfect.
supposed to return them. That was the,
Okay,
Perfect. Ms. Smolders, if you could follow up with your client about that. If you need
Sure.
another copy, you can just contact Ms. Herman.
Okay, sounds great. Thank you.
Thank you, guys.
Thank
We're
you.
adjourned.
bye-bye.
You can come right up to the table for me. You must be Miss Carrier.
Yes.
All right. I'm good, Miss All.
You're good.
Court will call the matter of Carrier versus Carrier 2258603DO. This is the date and time scheduled for a motion to enter a default judgment. Are you Ashley Carrier?
Yes, ma'am.
Will you raise your right hand for me? Do you solemnly swear, oath, or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you're here today for a motion to enter the default. Do you expect Kevin to come today?
No.
All right. you state your name for the record?
Ashley Christine Carrier.
And Ashley, you've provided me with a copy of a default judgment of divorce. Did you provide a copy of that to your husband?
Yes.
That judgment of divorce provides that spousal support is not being awarded and spousal support is forever barred. Do you understand if I sign that judgment today, you cannot come back later and request spousal support?
Yes.
You've already divided all your personal property. You're each going to pay the debt in your own name. Each of you is keeping your own vehicle and responsible for that debt. You don't own any property together?
No.
No pension, annuities, or retirement accounts?
Yes.
Asking for your name to be changed back to Ashley Christine Van Wyk?
Yes.
He's going to be responsible for the Forefront Credit Union approximate balance of $2,000.
Yep.
All right. During the marriage, there were no minor children born.
No, ma'am.
When you filed your complaint for divorce, were all of the allegations in that complaint for divorce true and accurate at that time?
Yes.
Do they remain true today?
Yes.
Prior to filing your complaint for divorce, had you lived in the state of Michigan for at least 180 days?
Yes.
And the county of Newaygo for at least 10 days?
Yes.
Were you married to the defendant on or about August 20th, 2021 by someone authorized to perform marriages?
Yes.
Is it true that there's been a breakdown in the marriage relationship to the extent the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Is it true that you are not currently pregnant?
Yes.
Do you have any questions for me before I sign the judgment of divorce?
No, ma'am.
Anything else you want to tell me today?
No, ma'am.
Court finds that proofs have been properly taken. The judgment of divorce appears to be fair and equitable on its face. I've signed the judgment of divorce today, February.
Alrighty.
February 1st, 2023, making your divorce official today.
Awesome.
If you want to go back down to the windows, they can come get the file and give you your copies before you leave today.
Okay, thank you very
Good luck
much.
to you, ma'am. We're adjourned.
Thank you.
Thank you. Last thing was 11:30, I think. 2358736 DM. This is the date and time scheduled for a petition to establish paternity. Mr. Greer is here on behalf of the plaintiff. Plaintiff and defendant are both appearing by Zoom as well. Mr. Greer, why don't you tell the court what you're asking for?
Well, Your Honor, it was my understanding that we were asking for my client to have be afforded the right to have a paternity test to determine the paternity of the child or during the marriage. However, it's my understanding, I think, that the parties have discussed this matter and my client wants to drop that petition. Is that correct, Corey?
Yeah, I just want to take her as my own and just be the father regardless. So legally, I am the father already. So, and then when we talked on the phone the other day with my wife next to me, we had decided to try and I would just take her as my own and claim her as mine. So.
Okay.
Ms. Kirk, is that your understanding?
Yes, it is.
All right, so at this point in time, no one is going to request a paternity test and everyone is satisfied with the paternity as it is established right now, that being Corey as the legal father.
Yes.
All right, the court then will allow Mr. Greer to withdraw his motion, and the motion will essentially be dismissed at that time, or dismissed today. Anything else for the record?
Mr. Greer, is it would I have parenting time like 50-50, or does it have to be a whole separate case?
No, it's not a separate case. We need to discuss it with Jamie and try to come to a resolution with respect to the visitation. Was there another child that was?
Yeah, I want to adopt him. I want to adopt CJ, my stepson.
Gonna have to adopt him before you get divorced.
Right, that's what we were discussing, and she's in agreement with doing that. His legal father has never been in his life, and I have always been in his life, so I'd like to take on the responsibility of adopting him also.
All
Well,
right, so there's a couple of things then that you're gonna have to talk to Mr. Greer about before we can move forward with that. So I'll let you get in touch with Mr. Greer, discuss what options are available for you and your wife, and then we'll go from there, okay?
Yes, ma'am, sounds good.
Thank you, Mr. Greer. Thank you, guys. Have a good day.
Thank
thank you,
you,
Your
Abby,
Honor.
also.
Feel free to call me, Corey, and we'll set something up.
Date and time scheduled for a hearing regarding a review of support abatement. This matter was adjourned back in October. I set it for today's date. Ms. Upson is appearing via Zoom. Mr. Johnson has not appeared. Ms. Haven from Friend of the Court is present. Ms. Haven, do you want to give us an update and tell me if you've heard from Mr. Johnson?
Support was abated May 25th due to a medical issue. I did get information that he was employed. I contacted the employer. They would not confirm or deny, so I sent an employer status disclosure. That was returned to our office. We received that February 2nd. It was signed January 31st by the employer that he had been employed at Pere Marquette River Lodge since November 17th, 2022. I did run a calculation, however, I'm wondering if the overnight shouldn't be adjusted.
Miss Upson, so you currently have 50-50 custody, is that right?
Yes.
All right, and is he exercising that?
No, right before Christmas, he told me that he only wanted to start getting Gavin on weekends. And then right after Christmas, he didn't show up on the Sunday he was supposed to. I didn't know he wanted to start that soon, and he didn't show up. So I had Gavin that week. And on the weekends that he's supposed to be getting Gavin, either his mother has him or he only takes him like from Saturday afternoon until Sunday when he meets me. So he's only had him like a handful of overnights since Christmas.
All right, are you gonna file a motion to change your custody and parenting time?
Yeah, I didn't know if I should or if I should just leave it alone or what, but I'm thinking I probably should.
Sure, so you can do whatever you want, but right now your child support order is based on 50-50 custody, and I can't really change that without a motion to change custody or parenting time. I realize that he's not exercising his 50-50, so I mean, it's up to you if you want to change the order to reflect what you're doing, which we always recommend, because in a year, if he hasn't been doing week on, week off, and then comes in and says he wants to do week on, week off, you'll be in violation if you don't send the child. So you really want the order to reflect what you're doing, and then child support would be recalculated based on those overnights.
Okay.
All right, Ms. Haven, would you agree with that?
Yes.
All right, what the court's gonna do is, I am gonna stop the abatement back to November 17th. So they're gonna charge him for child support based on your current order from November 17th now and moving forward until you file that motion to change custody. My understanding is that's not a lot of child support because of the 50-50 custody arrangement, but it will at least get you some child support, and I'm gonna retroactive it back to November 17th when he started working. We specifically told him back in October when he was here that he needed to contact us and let us know if he was working, and he's been told that on more than one occasion and clearly didn't do that. So we'll get that order entered, and then it'll be up to you to file a motion to change custody, support, and parenting time, okay?
Okay.
Do you have any questions for me?
We're going back to the December 1st, 2019
Yes,
support.
thank you.
Okay.
So it's technically, we'll do December 1st, just because that's easier for billing.
No, I was
Okay,
the
that's-
December 1st, 2019 was the last time it was set.
Oh.
I'm just asking, is it going back to that? That's what
So,
was abated.
sorry, so that was abated, what was that based on?
I believe similar 50-50.
Okay,
They both were imputed. Ms. Upson did have one additional child that played into the calculation, so That was 35 child support, 18 medical support. That's what was abated.
What's he making at Pure Marquette?
He's making $13 an hour.
Yeah, we'll just leave it at the 2019 calculation and the effective date, whatever makes sense, Miss Haven, if it's November 17th or December 1st.
I can do either.
We'll do November 17th because he should have called me. November 17th, 2022 will be that effective date. But it'll be based on your old child support order. Go ahead, Miss
Okay.
Upson, did you have a question?
Nope, I was just gonna tell you that I think I'm all set for right now.
All right, thank you, Miss Upson. Good luck to you.
All right, thank you. Have a good day.
You too, we're adjourned. Versus Gulliver 1654710 DO. This is the date and time scheduled for motion to enforce the judgment of divorce. Are you Tiffany Gulliver?
Formerly known as, yes. I am no longer
Yeah.
Gulliver last name.
All right, is it Tiffany Taylor now?
It is currently Taylor, correct?
And sir, you are Scott Gulliver?
I am.
All right. Miss Gulliver, why don't you tell Miss Taylor, why don't you tell the court what you're asking for?
I am looking to understand why Mr. Gulliver, the defendant here, is not following through with court orders, and looking for justification of that.
Okay, so in reading your pleading, you've alleged that your name is still on the Westgate timeshare, I guess it is.
Yes, that is accurate.
All right, Mr. Gulliver, we were here, I don't know, in 21, I think, talking about the same issue. Is her name still on that timeshare?
It is.
Okay. And how come you haven't gotten it off yet?
Well, it's been paid in full. The maintenance and taxes have been paid and are current. I paid the 2023 taxes that were due January 1st. I paid them back in December of 2022. So everything's current. The thing is Ms. Taylor thinks that this has just been an easygoing thing getting this through with the timeshare thing, but I've only been getting the runaround from Westgate, and they have not been helpful. And then you know, I sent them the quitclaim deed with the money. They sent it back. Okay, why did you send it back? Oh, well, you got to give it to you got to go through the county first. Okay, well, why didn't you tell me that? You know, so I sent a check to the county. Then they sent it back. Oh, we don't take checks. You got to have a cashier's check. And then in the meantime, I moved, and I haven't, to be honest, I haven't located the paperwork. Yeah, they're here. They're somewhere. They're packed away. I've been looking for them, but nothing should be negatively shown on her report. Everything's paid. It's just the last little final detail of getting it in my name that have had no help from Westgate or the county.
Miss Taylor, response?
I have troubles believing his statements. I have contacted Westgate multiple times, have had awesome customer service. I was informed back in March 9th of 2022, per my notice of hearing information there, that at that time they sent back the check, the deed, and the forms that were needed to be completed with explanation to him. I'm not sure if at that time that's when the county situation came in or not, prior to that or not, but still March 9th of 22, following that paperwork is after your deadline of February 13th of 22 per our last hearing for starters. And now we are almost still another year past for him to fill out that paperwork. I just, again, I find that absurd. I feel that he is dragging this on. I feel that he is not giving this prompt attention. To my awareness, he moved back in April of 2022, last year. So if this was something that was important to him, I feel that this should be on his top priority list. I mean, if we get tags in the mail to renew our vehicle license, or we have, you know, things to accomplish for a marriage or something for our job, that is a timely factor. Again, those are just things that we put at the top of our priority list. Our divorce was finalized in 2017, and we are almost 5 years in the making of this process.
Your Honor, may I say something?
Sure.
If she wants it, she can have it back. You know, she can, I paid for it. It's up to date on taxes. It's in her name. Why don't she just keep it? She can give it away. She can sell it. She doesn't have to, you know, the next maintenance and taxes aren't due until 2025.
Miss
Just-
Taylor?
Just give it back to her and just let her sell it. Let her give it away. She's not out on any money.
It is true that I wouldn't be out of any money, but my concern is then this situation is flipped. Then he would need to provide me with a quick claim deed,
No,
and I would
it's-
need to process that. Is my understanding?
It's in your
Scott, do you
name.
know that to be true or not?
It's in your name.
But I would need to take it out of your name.
It's
Like
not
we
in
are
my
in the
name.
situation now.
It's not in my name. That's why you brought me here today.
So it's
How is
not
it
in
not
both
in
of
your
your
name?
names? It's only in, it's not in both of your names? It's only in her name?
Yes, ma'am.
I would have to look into that. To my knowledge, we were both on the account.
No, we are not. We are not on the account. My name is not on the account. I log into the account, but I'm not. My name's not on it.
All right, Miss Taylor? Can you live with that resolution?
If that is truly the situation, then yes, I agree. I will take over full responsibility for Westgate Timeshare, and he will no further have responsibilities if, keyword, if that is truly the situation. I can verify that with Westgate today.
All right. The court would order that Miss Taylor receive the Westgate timeshare free and clear of any claim by the defendant. The defendant would cooperate with making any transfers if need be. And Miss Gulliver, you'll have to do an order. Never mind. I'll have my staff do the order. It's going to be too
Okay.
confusing for you to do that.
Okay, thank you.
But I'll do the order so that it says basically it's reversed from the judgment of divorce. Westgate Town Center Resort and Spa. All right, we'll get the order entered, and then Miss Taylor, that should be all you need. And then hopefully you can get it sold or taken care of, and you won't have to come back again.
Sounds amazing. Thank you.
Thank you, Mr. Gulliver. Thank you,
Yep,
Miss
thank you.
Taylor. We're adjourned.
Thank you for your time.
Bye.
Good morning, Miss Ramo. You're muted. I just need you to unmute yourself there on the bottom of the screen. Court will call the matter of Ramo versus Ramo 2258321 DM. This is the date and time scheduled for a settlement conference. This matter is scheduled for trial, I think next Friday, the 10th. Mr. Greer and his client are appearing via Zoom. Mr. Helder and his client are both also appearing via Zoom. Mr. Helder or Mr. Greer, can either one of you tell me where you guys are at, if you're ready for trial, or if you think you're going to get it resolved before then?
Uh,
I'll
go
say
ahead,
something.
Joe.
Judge, we have a lot of outstanding issues. As you may know, I'm late to this case. There was a lot of procedural history before I took over for Courtney. And my understanding is that as she was not represented, none of these issues got addressed. She was under the impression that there was literally zero equity in the marital home. Turns out there's close to $75,000 in equity in marital home. We recently got an appraisal and it was 236. I recently received a mortgage statement indicating the parties owed about 162. It's clearly a marital asset. It was purchased during the marriage with $10,000 of my client's premarital property. And I'm missing a lot of discovery. I sent discovery requests. They were due in early December. I don't have multiples of statements that I requested.
Interrogatory.
Further, this plaintiff is $4,000 behind in child support and earning unreported income from renting out his house. So we have a lot of issues, and
Well, it's not just his house.
Okay.
It's not. His dad's on the house. So, good luck.
And your appraisal also says that it's not valid unless the furnace and septic are repaired. Maybe you should read your appraisal.
Okay, wait a second. We're not gonna argue. Hang
I
on.
don't know what the state equalized value is, Judge. Hang on. Maybe I do. I mean, Joe, don't make it look like it's my fault. I mean, I've just been waiting here trying to get a hold of you.
All right, so what is the discovery that's left outstanding? I mean, are you ready for trial in,
I don't believe I am, not after that statement. Hey, Your Honor, may I go for a second and get my secretary? Please.
Sure.
Thank you.
May I say something as well?
No,
I just want one thing.
no, you can't say anything. Mike's property.
I was just gonna say that I was in the hospital for a month and a half.
You were?
Yeah, I had my appendix removed.
wait a second, wait. All right, Mr. Helder, there's still discovery outstanding
Do
then?
we have, has he done interrogatories that he wants me to answer? I answered.
I have them over here.
Like answer them.
Hang on.
You guys know.
Answer the interrogatories.
Oh, okay. When did we mail?
Just down like.
Hang on, Mr. Helder, do you have, Mr. Greer, wait, I can't talk to Mr. Helder, I can only hear you. Mr. Helder, then, are you saying that there's interrogatories that you haven't received
Yes.
answers?
Plaintiff's prime account statements, PayPal statements, BFCU statements, Merrick Bank account balance, auto loan statements.
LMCU statement also.
Have
She
you
has
reached
access.
out to Mr., I mean, have you reached out to Mr. Greer to let him know what you're looking for, what's left, or?
I've never talked to him to the best of my knowledge. Yeah, okay.
All right. Mr. Greer, he says he hasn't received those things. Was that part of the discovery request, or that's something you asked for later, or what?
It's your standard set of discovery requests that you get in a ICL thing, and so I would imagine it's in there. I don't know, though. I haven't personally heard from him that he needed more information. I haven't seen a motion. So I don't know. We provided it to him. I'm trying to look at the date, but my client was also in the hospital for
My appendix.
his appendix burst for about a month and a half, I guess, or out of commission.
All right, so I'm assuming what I'm hearing is that there's discovery that you don't think you can finish in a week and a half, so you're asking to bump the trial, is that right?
I am, yeah, but I didn't realize that there was that, so yeah, I
Mr.
do.
Helder?
I'm not interested in dragging this case out. However, we can't even agree that the house is marital. I mean, these parties have never, why didn't these parties attend mediation? I have no idea. Could have been very, very helpful.
Well, we didn't have your intuition and your experience into these things. It certainly would have been nice if you'd have been involved in the beginning. I could have set it for mediation and learned some things.
Judge, I'm sorry. I'd love a understanding of where you would lean on this house. I mean, they're claiming that because it was a co-signed mortgage and his dad is on the title, that it's somehow not marital.
I'm not saying it's not marital. It's just.
Would you please be quiet?
All right. This is one thing. The court's going to move the trial date to March 2nd. Does that date work for either of you? It's a Thursday.
Hang on a second, Judge.
Okay.
Where's my book or a book?
Mr. Helder, does that day work for you, the 2nd?
I am currently checking.
All right.
I have a settlement conference in Berry County at 10:45. I'm guessing that's Zoom. So if we can schedule for an afternoon, that's probably doable.
It's open now, but you know what Thursdays are, Judge, so I don't think it's gonna be open, in a few days, but
What
I'd
about March
prefer.
1st? What about March 1st? It's a
Hang
Wednesday.
on.
That works for me.
Yeah, that'll be fine.
I know you usually do pleas and sentences every other. Is that
It
your?
doesn't appear to be on there, Judge, so hang on. I'm gonna schedule it and take the
Reschedule the
meeting.
trial for March 1st at 9 a.m.
Very good.
In regard to the house, I know nothing about the house. I don't know only what you just told me. So I think it's come up in other hearings, to be honest with you, discussion about the house, but I don't know any details. Look, obviously, if he's a co-signer on the house, that doesn't make him, in my eyes, a joint owner that would somehow excuse or eliminate the marital equity that might be in that marital home. Clearly, if she had $10,000 that they used for a down payment, and they used money that they earned during the marriage to pay down that mortgage, then you're gonna have obviously marital equity in that home. However, if dad was more than just a co-signer, he lived there at some point, he owned it before them, he was making the payments on the house. I don't know if there was an arrangement like that that would change my opinion, but just co-signing on a mortgage would not eliminate the marital equity that was earned if they made those payments. So Mr. Helder, clearly there's some issues with discovery, and Mr. Greer, so you guys need to talk to each other. I'm not going to adjourn it again. If when we come on the 1st, we're going to have that trial because my drop dead date is in May and we got to get it finished. So I'll adjourn the trial date for February 10th, but that new trial date will stand, and I'm not going to put anybody else on there. You'll go on the 1st, March 1st. Now, in between now and then, if you guys think you can get into mediation and do mediation before you come back, certainly I would love to have you do that. You know, I've been telling Miss Ramo from the beginning that she would benefit from having an attorney on her side. So hopefully now that she has an attorney, you guys can work through some of these issues. I think the other custody issues, as I understand it, she's moved back. And they're attending school, I think, here in Newaygo County, which obviously I would assume will make that issue a little bit easier as well. So anything else for the record today?
So we're gonna be doing the custody that day as well, correct?
Yes, it'll be the entire divorce
So
trial.
if you guys agreed on it?
We got signed paperwork from Melissa saying every other week.
So that's a temporary order, but yes, you
Okay.
guys can make that a full order, and if you guys want to agree that custody is, finalized, and the only issues for trial would be property, you can certainly do that, but you'll have to talk to Mr. Helder, and he'll have to talk to his client about that.
I'm fine with that custody agreement, but I would need a well-being check on her house because I don't believe it's suitable.
All right, so I'll leave you guys to discuss that. The trial's off for February 10th, and I'll see you in March.
Thank you, Your Honor. Sorry,
We're
Joe.
adjourned.
Thanks.